Welcome back to my deep dive on the law of the TikTok ban. Today we're going to talk about the creators brief. Remember that there are a group of creators who have also filed a lawsuit. That lawsuit has been combined with the ByteDance and TikTok lawsuit, but they have filed a separate brief. They have separate lawyers. They have separate interests. So let's get into what they said. Keep in mind that all of these creators are United States citizens. One of them is a company. First of all, the creators say that the TikTok ban is going to restrict their rights under the United States Constitution under the First Amendment. It'll restrict their right to speak on a chosen platform, receive information and ideas, and it restricts their freedom of association under the First Amendment to associate with their chosen platform. The creators say that strict scrutiny needs to apply because this is in fact a content restriction. The creators brief goes into a bit of a thought experiment. The creators don't want to argue about whether or not the algorithm is controlled by China or not, because the way they see it, it's irrelevant. So they say, you know what, let's just assume for a minute that the algorithm is controlled by China, and let's assume for a minute that China is manipulating that algorithm to show Americans information that China wants them to see. The creators say that even if Americans choose to use a platform that promotes Chinese interests, that their rights to use that platform that promotes Chinese interests is protected by the First Amendment. That's a really interesting and creative argument. And they use that argument to illustrate why this ban is in fact a content-based restriction on speech. The creators say that the divestiture option does not cure their issue with the restriction on speech. They give some great analogies. They say that that would be like forcing an actor to work with a different director, a writer to work with a different publisher, a musician with a different studio, and that it severely limits their audience. I think these are great illustrations for why their choice of platform is speech in and of itself. The creators brief then goes into the United States history of foreign interference in United States citizens' thought. I really enjoyed this section of the brief. I thought it was really interesting and made me think about these issues in a completely different way. They give the example that way back when Thomas Jefferson was running for president, the French published op-eds in newspapers supporting him for president. That would be a foreign government interfering in a United States election. However, nothing was done about it. It was not seen as speech that needed to be interfered with under our new United States Constitution. They give the examples that Voltaire, John Locke, and Hale, who are all founding philosophers of democracy, were all foreign. Yet their writings were widely distributed in the United States. They point out that Karl Marx's Communist Manifesto was widely distributed and published in the United States, and no restriction was ever placed on it, despite the Red Scare. They give the example that during the Cold War, there was even Soviet propaganda that was being translated and published in Columbus, Ohio, and then distributed nationwide. No restriction on speech was placed there. Their point in giving all of these illustrations is that even if China is trying to influence our thought process by showing us different videos that they want us to see and inflaming certain issues, that this is not a new issue. This is an issue that has existed as long as the United States has existed, but never has the government seen that they have a right to interfere in how speech, whether domestic speech or international speech, is distributed in the United States. They even point out that in print and broadcast publishing, which have greater restrictions on them than the internet, that BBC, China Today, and even Al Jazeera have never been regulated in the United States. They point to a really interesting case called Lamont v. Postmaster General. This goes back to the Red Scare again. In that case, there was a federal law that said that you can't just mail communist propaganda to anybody. People have to specifically request communist propaganda before you can put it in the United States mail to them. In that case, the court said that Congress may not control the flow of foreign ideas to United States citizens. It was really interesting to see how the TikTok ByteDance brief really focused on the ownership issues and the foreign control issues, whereas the creator brief focused more on the expression of ideas, the choice of forum as an expression in and of itself. The creator brief really used this thought experiment of what if TikTok really is communist propaganda from China? If we want to use communist propaganda from China, we can. We have the right to do that as American citizens. Stay tuned because we still need to cover the government brief. I want to do a video on divestiture option and what that means. There's a few other loose ends we need to wrap up before we get to the live argument on January 10th.